2 o'clock. I haven't spoken with Jim. I expect him to come, but seems like we could just go ahead. We're just get sort of the mechanics of the meeting out of the way, and we'll get started. So, good afternoon. I want to call the meeting to order now. Start by saying, as chairman of the Albemarle County Board of Zoning Appeals, I call the meeting for November 10th, 2020 to order. This is an electronic meeting. Please be patient as we all become familiar with this meeting alternative and virtual process. This meeting is being held pursuant to and in compliance with ordinance number 20-A (14) an ordinance to ensure the continuity of government during the COVID-19 disaster. The BZA members who are electronically present at this meeting are, and I was saying, Ed Robb, Randy Reinhardt,
Present.
Marcia Joseph, Edward Carrington, and myself, John Shepard. And in a moment, we'll just ask you all to identify yourselves again. The opportunities for the public to access and participate in the electronic meeting are posted on the Albemarle County website, on the Board of Zoning Appeals homepage, and on the Albemarle County calendar. Participation will include the opportunity to comment on those matters for which comments from the public will be received. We'll remind you there's no public hearing today, so there won't be public comment. First, want to officially establish a quorum. If everyone here will just state their name. Why don't we just start in the upper left-hand corner with Mr. Robb and just go around the circle. Mr. Robb, can we hear you?
Ed Robb, present.
Right. And I'm John Shepard.
Randy Reinhardt, present.
Doug Carrington, present.
Thank you.
Marcia Joseph, present. I think we all may be arranged differently on each other's screens, John.
So many opportunities for, well, Zoom meetings. They have their foibles. Okay, so we have definitely established a quorum. We're all here. Also want to recognize Bart Savota, the zoning administrator. I see Francis McCall, who's on the staff. Andy Herrick, deputy county attorney, who has a big part in the meeting today. Marcia Alley, clerk to the BZA. And once again, thank you for putting the meeting together. I see Lisa Green is also here, who's on the staff. As I said before, there are no public hearings during this meeting. So we're going to move on to the approval of the minutes for October 6th, 2020. Does anyone have any comments? I have one. Yes, Randy?
Oh, I'm sorry. Go ahead, Mr. Chairman.
I have a very nitpicky little, it's practically a typo. Page 2, line 3, delete the word "it." It's it just fixes up the sentence. He noted that the county is fortunate to have this available. He noted that the county is fortunate. Delete the word "it," and I think they're perfect.
And Mr. Shepard, did you say page 2?
Page 2, line 33.
33. Okay, thank you very much.
Yep.
Delete it.
Exactly. Any other
Yes, sir.
comments?
We can take care of that.
All right, thanks. Any other
Mr.
comments?
Chairman, I move for approval, and I'm glad you don't read my English papers.
Thank you for that. Is there a second?
I second.
Marcia, could you call the roll, please?
Ms. Joseph,
Aye.
Mr. Robb,
Aye.
Mr. Reinhardt,
Aye.
Mr. Carrington,
Aye.
and Mr. Shepard.
Aye. Okay, so the minutes from the October meeting are approved. Thank you for that. want to turn now to old business. Bart, any old business? Marcia, could you turn on his mic?
Sorry about that. Mr. Moss has submitted and recorded a boundary line adjustment, which now makes that building meet setbacks. So we will be looking at processing out his particular application, and I can give you an update in December on where we are with the rest of that.
Does the rest of that include, has the appeal of our, the variance and the appeal of the BZA to the circuit court, has that been withdrawn or is that still active?
It's still at a standstill until we finish processing the application. Once he's in compliance, then we'll get with Mr. Herrick and figure out how to proceed from there. What those
Okay.
steps are as far as how the approval will affect that.
All right. Mr. Herrick, do you have any further comments on that? Is that where it stands?
That's my understanding. Yes, sir.
Thank you. Any other old business from anyone? I hear none. Let me see where. Is there any other new business anyone wants to talk about besides the training? No. So we're now going to go pick up where we left off at the last meeting. Turn this over to Andy Herrick to continue the training that we were working on in our last meeting. And again,
Good.
just by way of introduction, I think, Andy, we really appreciated it last time and appreciate you doing it now. This is a useful thing. And I'm just very appreciative that the entire BZA is hearing this, in the same, at the same time and almost the same place. To hear it together, I think is very valuable. It sort of reinforces it for all of us. Hello, Jim. I see Mr. Bowling is here, our BZA attorney. We're just getting started with the training now. And I'm also glad some folks from the staff are here. I would, as we get into maybe at the very end, I would welcome staff to participate to an extent in discussions we might have, because we're all living with the same rules here, and I think that would be helpful. But anyway, to summarize that, just Andy, I appreciate the work you've done with this and look forward to hearing what you have to say today.
Great. Well, thank you very much, Mr. Chair. Can everyone hear me okay? I've got a bit different setup than I'm used to. I'm actually in the office today, a rare occasion, and I'm using just the laptop microphone instead of my usual earbuds and mic. So this is a new setup, and I just want to make sure before I get started that we're good. It sounds like we are. So again, Mr. Chairman, members of the board, I'm Andy Herrick with the County Attorney's Office, and I want to thank you again for inviting me to come back and continue the training that we started last month. As you'll recall, last month we went through a number of different land use concepts. We reviewed the role of the Board of Zoning Appeals. We talked about the major items that come before the Board of Zoning Appeals, including special use permits, variances, applications for appeal from determinations of the zoning administrator. So we managed to get about 3/4 of the way through the prepared training. The remaining 1/4 that I hope you cover today deals with the Freedom of Information Act and the Conflict of Interest Act. And those are most applicable. It certainly helps that staff is here for that as well, but really Freedom of Information Act and the Conflicts of Interest Act, I think will be of special application to those of you who are serving on the public bodies. Not just, and I would add very quickly that they don't apply just to members of the Board of Supervisors. They also apply to members of any public body, include the Board of Zoning Appeals. So with that, I'm going to go ahead and attempt to share my screen. And so right now, I am hoping that you see, can you all see my slideshow here?
Not yet.
Okay. What about now? Can you all see the slideshow at this point?
No.
Okay. Is that any better?
No.
Okay.
Hang on, Andy, let me see if I can help you.
Okay.
See if that will help you.
Well, you all tell me, because I'm seeing it on multiple screens where I am, but if you're not seeing it, then I need to keep swapping out screens here.
You haven't picked the right one yet.
Okay.
There you go.
Very,
Okay. Now, if you see the slides from the slideshow, there should be meetings and FOIA as the first slide. Do you all see that?
Yep, the guy looking through the Venetian blind on the flag.
Okay. And just
Wait.
slide number 94. Very good.
and Andy, we do see that, and we see slide number 94, as well as the introduction. There you go. That's better.
Very good. All right. Now we're ready
Thank
to
you.
roll. Thank you for bearing with me while I got this sorted out. As you all know or may know, I actually gave this same presentation earlier this month, or actually late last month, to the statewide audience in Richmond. And it took me a minute or two to get that set up too. When I'm doing full screen on a slideshow, that's a logistical challenge. But in any event, so we're going to pick up with FOIA, the Freedom of Information Act. And the purposes of the act, it requires that meetings of public bodies be public. And as I mentioned briefly, public bodies are not just limited to local governing bodies like boards of supervisors and city and town councils. They also include the Board of Zoning Appeals. And the reason for this, and this is written right into the Freedom of Information Act, and it's probably my favorite passage from the act. It says, the affairs of government are not intended to be conducted in an atmosphere of secrecy, since at all times, the public is to be the beneficiary of any action taken at any level of government. So in other words, since the citizens, the public, are the beneficiary of government actions, it makes no sense for the business of government to be conducted in secret. And again, that's written right into the state law, and I like very much that it's in there. So we're going to start our discussion of FOIA with 8 basic principles, the first of which may be the most important, and that is that a meeting of the members of any public body may exist when 3 or more members of the public body are physically assembled for the purpose of transacting or discussing business. So as I may have shared with some of you individually, if at least 3 of you are gathered and you're discussing public business, it is considered a meeting, regardless of whether the meeting is in session, regardless of whether the meeting has yet to be formally called to order, or even after the meeting is adjourned. So sometimes occasionally I'll stick around after the meeting and you all are enjoying a nice after meeting discussion. And you know, one of my roles is to kind of remind you all that when at least 3 of you are discussing, there needs not to be a discussion of any sort of public business. You can discuss football games, the weather, other things like that, but public business would not be allowed, because then that would become a public meeting. So if 3 or more members of a public body are assembled, but not for the purpose of transacting or discussing business, such as at a dinner, a meeting is not established, again, provided they do not transact or discuss business. So again, weather, football games, traffic, those are all acceptable topics, as long as it's not traffic related to land use. But again, once public business starts to be discussed, then it becomes a public meeting. The next principle is that electronic communication, such as emails or text messages between 3 or more members, may be an unlawful meeting if the communications are conducted in real time. And I think that this is a frequent misconception, because sometimes I see members of public bodies say, respond only to me, so that we're not running afoul of FOIA. And while I appreciate the concern, it's really not so much that you can't do a reply to all members. It's just that it can't be in real time or in live time. Unfortunately, there's only one Supreme Court case that I'm aware of that really addresses this issue. And it dates to kind of the early days of email, when there was a discussion taking place among members of the Fredericksburg City Council regarding an issue. And at that time, again, the Supreme Court was still trying to figure out, trying to categorize email. What type of communication was it? Was it more like the traditional snail mail where you write something and pop it in the mail and 2 days later it arrives? Or is it more like a phone call in which you're carrying on a live conversation? Because an exchange of snail mail letters wouldn't be considered a meeting. But if all the supervisors or board members were to get together on the phone at the same time, then that would be a meeting. And what the Supreme Court decided was, as long as it wasn't simultaneous communication, in that particular case, the case of the Fredericksburg City Council, I believe that the messages were about 2 hours apart. So the Supreme Court decided in that case it was not an unlawful meeting. So again, the problem here isn't so much how many different members you communicate with at once. It's, are you essentially having a live chat? Because that's what would make it a meeting that would run afoul of FOIA.
Andy, can I ask something here?
Yes, please.
Although it's not a meeting, it is disclosable under FOIA. So that if a board member not in real time sends out a letter or what have you to all the other board members and an FOIA request is made, that disclosure by email is subject to FOIA, correct?
Yes, that's correct. And Jim raises a very good point. What we're going to be talking about today in FOIA is just the meeting aspects of FOIA. FOIA has two primary topics it deals with: public meetings and public records. And as Jim points out, almost any document that comes before the Board of Zoning Appeals would be considered, in fact, they would probably all be considered public records. Some may not be disclosable due to very limited exceptions to the rule. But again, as Jim points out, and I think it's a point well taken, that most of your documents are also going to be considered public records. Going further down the list when it comes to sort of meeting principles of FOIA, public meetings are the rule, closed meetings are the exception. In order to be in a closed meeting, you have to find an express exemption. And so some of the questions, one of the questions that comes up is, well, what are those exemptions? What specific types of exemptions might apply to a Board of Zoning Appeals? And I think you all are aware of at least one of them. Personnel decisions of a BZA, or personal decisions really of any public body, are a proper subject for a closed session. Also, consultation with legal counsel regarding litigation or specifically identifiable legal matters. Those are also proper topics for closed sessions. The next principle is that a meeting may be established under FOIA even though a quorum is not established. In your case, the quorum is 3, and it takes 3 members to create a meeting as well. So in the case of the Albemarle BZA, a quorum and the trigger for a public meeting are one and the same. If a quorum is not established, the only action the public body may take in a meeting is to adjourn the meeting. Now, that's not to say that there can't be a discussion of ideas, but it's not official business because, again, no business can be transacted without a quorum. And finally, the last one's a little complicated. If the number of members of a public body otherwise falls below that constituting a quorum because one or more members are disqualified because of a conflict, the remaining members constitute a quorum for the conduct of business and have the authority to act. That's a long way of saying basically you can't lose your quorum solely on account of a conflict of interest. So if you start with a quorum and then one or more of the members have to disqualify themselves due to a conflict of interest, the remaining members, even though they would fall below 3, would still be considered a quorum.
Can I ask you a question just for
Yes, ma'am.
When we're talking about consultation with legal counsel, and we were talking about it being an oral or verbal sort of thing going on, what about counsel by email? Is that something that is FOIable or not?
Typically not. Those records can be withheld from disclosure, citing attorney-client privilege. Jim, I don't know whether you want to add anything to that.
No, I mean, I think they're not disclosable under
Right.
attorney-client privilege. Now, the member can give away the privilege. The attorney can't, but the member can.
Oh, okay.
In other words, if you take my advice and give it out to the general public, at that point, it loses its attorney-client privilege. Is that right, Andy? Do you agree with that?
Right. I agree that privilege can be waived. So in addition to being able to consult orally with the attorney in a closed session, the public record, so the emails that might be generated back and forth with an attorney would be subject to attorney-client privilege. One area where that may come into that may be jeopardized is suppose that one board member were to email the attorney, and then the attorney and that one board member had an exchange, and then the one board member forwards that to another board member, then that's questionable whether that communication between board members sharing the advice of counsel could still be privileged. So something to keep in mind when you're sharing those communications.
Thank you.
Can we go back to the email question?
Sure.
Good if you could describe that sort of in the positive. Like, what would be proper email amongst the board that would not run afoul of the meeting rules? I'm just wondering, I mean, for example, can I send an email out to everybody saying the meeting on Tuesday is being moved to Wednesday, or beyond that, or just I don't understand what is permissible, what is permissible with emailing more than one member? What are
Again, it's not so much the subject matter, it's the simultaneity. So I guess my suggestion for you would be if you were to send out an email saying we're moving the meeting, and then that triggers a number of very quick email responses, and you find yourself kind of descending into a discussion, somebody at that point needs to pump the brakes and say we're exchanging emails at such a pace that this is more akin to an actual meeting, and we need to delay further discussion of this until we're actually in an open public meeting. Does that address your question?
I think so. It almost feels like it's you'd know it when you feel it. You can just sort of feel yourself getting close to the edge and be aware of that.
Unfortunately, there's not a bright line rule, so that again, what the intent was to avoid a meeting. The thing you need to avoid is a meeting, and what looks and sounds like a meeting is when you're engaging in live time simultaneously. So, Jim, did you have additional thoughts on that?
No, just that if it's a housekeeping matter, as long as you're not dealing with substantive matters, you're going to more or less be okay, John. So if you send an email to the members saying, can everybody meet next Tuesday, and somebody else chimes back, no, but can we do it on Wednesday? And then you say, is Wednesday okay with everybody? And there's a time lapse, then that's fine. If you try to do it by conference telephone call, that gets a little tricky. I wouldn't do that.
Right.
But I don't have any problem with using emails to set up dates. It's the substantive context that's really going to get you in trouble. I don't know.
Right. But if okay. I think I understand that. And we'll
so much the subject matter as it is the simultaneity.
Okay, well, that's true too. But emails are not simultaneous. It takes you send it off. It doesn't, somebody has to respond back, and it takes a while.
Again, in the one case that's been before the Supreme Court, there was a delay of several hours. The Supreme Court, to my knowledge, has yet to adjudicate a case where, the break was 5 minutes or 10 minutes or something like that.
Yeah. So if they get into a situation where they say that sending an email out and somebody else responds in 5 minutes, it's okay with me, and that's a meeting, then that's it'd be interesting to see if they do that. That would show, but we're waiting for the case.
And I agree, Jim, that as a practical matter, if all you're doing is setting the time of the meeting, the Supreme Court might be a little more generous in saying, that's not a substantive matter. So practical matter, I agree that if and when that case came before the court, what you all were discussing probably might enter into the equation. But again, the only guidance we have at this point is is don't have what amounts to a chat. I mean, these days, you've got the little chat features. Some programs have a including Zoom, by the way, has a chat feature. And I think that if one were to transact business in a chat, probably would be considered a public meeting, because the whole purpose of a chat is to have real quick back and forth between the members, which again looks a lot like a meeting.
I think the safe point, go ahead.
No, I'm sorry. I was ready to move on, but if you have other questions, we can keep talking about what constitutes an electronic meeting.
I'm thinking for me, anytime I'm getting close to a gray area with that, my inclination would be to sort of follow the procedures that we've done in the past, where, if I'm trying to, communicate with you, Andy, or with you, Bart, about some aspect of, some upcoming business, to go through Jim and let that go, follow that channel, like for me, over to Jim, like up to Jim, over to Andy, down to staff. And the same with, as far as speaking with other board members, just leave that, unless it's absolute housekeeping, which is usually going to come from Marcia. Anything but, avoid anything but just complete housekeeping, very simple announcing just announcements. I think I'm clear on that now.
It's probably best to err on the side of caution, but I think that probably most members of most public bodies are honestly more cautious than they need to be, which is a good thing. But again, I get back to as long as it's not an attempt to conduct business in live time. That's the thing that would have wound up creating a problem in the one and only case the Supreme Court has ruled on the issue. So, but although Mr. Chair, you did mention sort of a related topic, which gets more towards ex parte communications, whether members of the BZA should be communicating directly with staff, or whether it should go through the BZA council, or whether it should come through the county attorney's office. And again, I'm constrained from communicating directly with a represented party, which would include the members of the BZA. So that's why I usually communicate back and forth through Mr. Bowling. And then there's the separate restriction about ex parte communications between members of the board and staff. So that's something to keep in mind as well. Those are separate issues, separate and apart from FOIA, though. So FOIA, again,
Okay.
I'm sorry.
And then I have one further thing I want to say, and then we can go on, Andy.
Sure.
If you want to have an email sent to all the members and it does involve a substantive point, you want to make sure it's not disclosable under FOIA, you can send it to me, and then I can send it out to all the board members. And I think at that point, then you get the attorney-client protection. And this is off the subject, Andy, but it kind of arose from the discussion we've been having.
No, and I think that's right. And the advice that I have is I always ask clients or board members to make sure that not so much that all communications go through the chair individually, but that anything that you wish to preserve a legal privilege on, that all those communications go through the attorney. And that's not so that the attorney can be, the center of the world or anything. It's just so that any communication, when it includes the attorney, is more likely to be attorney-client privilege.
So let me ask this question. I just want to make sure I understand. Now that we have Jim as our attorney, if I have a technical question about an up and coming case, I can still contact Bart and ask him a question, correct?
No, you really shouldn't.
Oh, okay. So I have to go through Jim?
It would be best to go through Jim or through me, because non-legal staff the legal staff of the locality are exempt from that no ex parte communications restriction. But, and it's not that you can't contact Bart directly, but any communications that you would have with Bart, we would need to simultaneously copy the appellant or applicant as well. But the whole point, as we discussed at the last session, was there's not going to be communication going on between the applicant and between board members and the staff that doesn't also include the applicant or the appellant. that they need to be included in any communications that you have, that board members have directly with staff.
Thank you.
So the public bodies that are subject to FOIA, again, as we've discussed, it's not just the governing body, Board of Supervisors or City or Town Council. It includes Planning Commission, Architectural Review Board, and of course you all, the Board of Zoning Appeals. You come within the definition of a public body that would be subject to FOIA. So what constitutes a meeting? There are gatherings of 3 or more board members that are meetings. These are gone over. I've included citations of examples in the materials, and the materials, by the way, have extensive examples of what constitutes a meeting, what doesn't constitute a meeting, where exactly to draw the line between social occasions like holiday parties on the one hand, candidate forums, things like that. It can be a public meeting can be considered to have, or let me put it this way, a gathering of a member of the public body can be considered as a public meeting when you're serving on a committee. So if the Board of Zoning Appeals, for example, commissions a subcommittee or a committee to handle certain issues, those may be considered meetings of a public body as well. So I know that there have been some topics that have come up through the years where there's been a temptation to say, well, let's just have 2 or 3 of our members form a special committee that will look into this. And that's fine and that's allowable, but keep in mind that those would be considered public meetings that would also be subject to FOIA. At the materials, again, section 29-330 of the materials have examples of gatherings of board members that are not meetings under FOIA. So if the purpose of the gathering is not to discuss or transact any public business, then it wouldn't be considered a meeting. And again, I think the best example of that is some sort of social function. So we'll talk a little bit about electronic meetings. And this slide I had to go back and modify this slide a little bit because back in the pre-COVID days, there were a lot of requests of, well, do we have to actually meet in person? Can we have people that join in remotely, whether by telephone or by Zoom? And again, this slide is a little dated in that we've sort of adopted a new way of doing things over the last 7 or 8 months or so. But it bears reminding that this is actually the state law. This is what the state law is right now. That state law, the default option under state law, allows for limited remote participation, but with certain really limited conditions. First, the public body must have adopted a written policy allowing for public participation. So there has to be a policy that says we allow people to participate remotely. A quorum of the public body has to be physically assembled at a central meeting location, and the public body has to make arrangements for the voice of the remote participant to be heard by all persons at the meeting. And even then, even before you've set the framework to allow remote participation, the remote participant has to certify that they're unable to attend the meeting in person due to a temporary or permanent disability or other medical condition, or that the remote member is unable to attend the meeting due to a specifically identified personal matter, and even that's limited to twice a year. So these are what the default rules are, again, outside of COVID, outside of an emergency, and this is the law that we're going to revert to once we're hopefully through COVID. Now, you ask, how are we managing to do what we're doing at this very moment, which is conducting a remote meeting? And the way that we have addressed that is that Virginia Code 15.2-1413 allows that localities may adopt ordinances to assure the continuity in government. And as the chair reads at the outset of every meeting, he says, we're conducting this meeting pursuant to ordinance number so-and-so, which is the ordinance to assure the continuity in government. That provision of state law allows for localities to have, again, these emergency ordinances that allows the government to continue operating even in the event of a disaster. And the Attorney General has found that COVID is a legally identifiable disaster. So that has allowed localities like Albemarle to address or to adopt continuity of government ordinances. And one of the provisions of Albemarle's continuity of government ordinance allows for electronic meetings under certain conditions, like what we're having today. Specifically, Section 6 of Albemarle's ordinance authorizes electronic meetings of public bodies. But once the COVID disaster has ended, state law will revert to the slide that I just went over, which is remote participation only in very limited circumstances. I should say that's what state law will revert to absent any amendments in state law. You know, it's open to question whether the General Assembly, the next time they meet, is going to, based on our COVID experience, allow sort of a liberalization of electronic participation. We'll see, but keep in mind that what we're doing right now is really only during the COVID disaster. Once it's over, we're likely to revert to the prior rules. So we'll talk a little bit about closed meetings. Closed meetings are meetings from which the public is excluded. A public body may go into a closed meeting only for a purpose authorized by law. And one of the purposes is set out in the slide here, is for consultation with legal counsel. And it's not just having legal counsel in the room, it's to consult with an attorney and be briefed by staff about actual or probable litigation, or to consult with an attorney regarding specific legal matters requiring legal advice. And as you may know, one of the things that you have to do before going into a closed session is to identify the purpose for which you're going into the closed session. And it's gone a step further in saying you have to identify with some specificity the legal matter that you're going to be discussing with counsel. And so it's kind of a fine line when our office is preparing the motion to go into closed session as to how much do we have to reveal about what we're going to discuss in closed session without actually violating the privilege, giving away confidential information. So there's a fine line, because if one were just to say, we're going into closed session to consult with legal counsel, period, that may be insufficient under the Freedom of Information Act. One might have to say, we're going into a closed session to consult with legal counsel about a dispute involving something. And then the last point about closed meetings here is that although the public body may reach a consensus in closed meeting, any official action must be made in a public meeting. So you consensus in closed session, but then the official action would take place back in the public meeting. Talk a little bit about rules of procedure. That's also an element or a related topic to FOIA. That it's a good idea to develop and follow rules of procedure for conducting public meetings. And as you know, our BZA here does have rules of procedure. They include time limits. Failure to follow those rules doesn't necessarily invalidate an action so long as the necessary votes were received. So again, rules of procedure are what in legal terms would be considered directory rather than mandatory. You don't lose jurisdiction because the rules of procedure aren't followed to a T, but obviously the rules of procedure help maintain order. The materials here, this is more just of a placeholder and a direction to or a referral to what's in the materials. The materials go over in more depth rules of parliamentary procedure, establishing and maintaining a quorum. Some of the basic points about a quorum, as we've discussed, is that no action may be taken unless a quorum is present other than to adjourn the meeting itself. We've talked about the fact that a meeting under FOIA may exist even if a quorum is not present. And we've talked a little bit about how a quorum can continue when members are disqualified. This is something, fortunately, that hasn't come up, or that rarely comes up, and that is that the chair has the authority to maintain order at a meeting. And although members of the public may have the right to speak at a public meeting, the right to do so is not unlimited. And you can see I've included a quote here from one of the leading cases, Steinberg versus Chesterfield County Planning Commission, that officials presiding over meetings must have discretions to cut off speech when they reasonably perceive it to be or imminently to threaten a disruption of the orderly and fair progress of the discussion. So my suggestion there is to give speakers kind of a long rope, because in the case of Mr. Steinberg, for instance, Mr. Steinberg was appearing before the Chesterfield County Planning Commission and started making some pretty inflammatory personal insults of the planning commissioners. And the chair of the planning commission shut him down and had him escorted out. And he was, I think, right to do so. But the problem is that this then resulted in litigation that went all the way up to a federal circuit court. And if the chair in that case had just given Mr. Steinberg a little more rope, even as annoying as he was being, it would have all this litigation. So in other words, are you going to let somebody speak for another 5 minutes, or are you going to spend 5 years in litigation? Again, my suggestion is people do have a right to speak within the timelines that are set out in the rules of procedure. And again, as long as they're not creating a disruption. Here is kind of a list of the other procedural issues that are spelled out in the materials, along with the sections of the.
Andy, could you go back to that a minute? It's,
Yes, ma'am.
yeah, it's just interesting. So what you're saying is that if John is the chair and some member of the public gets up and has 3 minutes to speak, they should be allowed to say whatever they feel like saying within the 3 minutes and then get them cut off. Is that kind of what you're saying?
Yeah, not quite. In other words, if somebody got up and was immediately proceeded to create a disruption, the chair would have the authority to stop that. But I guess my suggestion would be to err on the side of permissiveness and patience. I think in our case with public speakers allowed to speak for 3 minutes, that's not as much of an issue, because at the end of the 3 minutes, time can be called on them. So I'm not going to say that the chair doesn't have the authority to cut off speakers, but the speaker should be cut off only to prevent disruption, rather than just because they're being repetitive or they're speaking irrelevant matters.
Okay, thank you.
Okay.
Thanks.
Are there any other questions? We're about ready to turn the corner into speaking about conflicts of interest. Do you all have any other questions regarding the Freedom of Information Act before we switch topics here? So we'll go ahead. The last item is conflicts of interest. And the purpose of the Conflict of Interest Act is to assure citizens that the judgment of public officers and employees will not be compromised or affected by inappropriate conflicts. So in land use matters, a conflict of interest most likely arises if an officer or employee has a personal interest in a transaction before the public body. And just for clarifying, members of BZAs are officers of a locality. So this would apply to you all. Here are some key terms to be defined. A personal interest means a financial benefit or liability accruing to an officer or to a member of his or her immediate family. A transaction is any matter considered by any governmental or advisory agency on which official action is taken or contemplated. So in your case, that would be an application, or an appeal would be a transaction. And a personal interest in a transaction would be a personal interest of an officer or employee or any matter considered by his agency. One thing I'm hoping that you're realizing in this discussion is that as far as the Conflicts of Interest Act is concerned, it's primarily concerned about financial interests. So oftentimes we get concerns about, I know this person socially, I have a friendship with them, they're a neighbor of mine, we're in the same civic association together, or we're in the same church or synagogue together, and do I have a conflict of hearing their case when it comes before me? Again, the Conflict of Interest Act is concerned about financial interests, and we'll talk a little bit more about the specifics of that going forward. And here on this slide, as a matter of fact, an officer or employee has a personal interest if he or she or a member of his or her immediate family has a minimum $5,000 interest, and that includes annual wages or income, or a 3% equity interest in a business or property. And let's pause there and define immediate family member. So that would be a spouse or any other person who resides in that house who's a dependent on the officer or employee. So if your spouse or if a dependent in your house receives either at least $5,000 in salary, or has a 3% ownership interest in an applicant, that creates a personal interest. But then the second criteria, in addition to the financial interest, is that the business or property is either the subject of a transaction, or may see a reasonably foreseeable benefit or detriment as a result of the action being considered. So again, there has to be a financial interest and then a reasonably foreseeable benefit or detriment to the matter that's coming before you all. There are two different ways in which you can address this. You can either be disqualified altogether if the transaction applies solely to the property or business in which the public official has a personal interest. So in other words, if the business in which you have an interest, or your spouse or family member has an interest, is the only party that has an interest in what's coming before the BZA, then you would have to disqualify yourself altogether. But if there's a group of 3 or more members that's being affected by the matter before you, you can disqualify you can disclose it. You can say, I have this interest, but I think that I will be fairly able to hear this matter. And there's a special form for that and special language for that that goes on the record. But again, if a group of 3 or more members is affected by the case, despite the fact that you have an interest, you can disclose that and proceed to consider if you can do so fairly. But neither disclosure nor disqualification is required if the transaction affects the public generally, because all the matters that come before public bodies affect the public in some small way. So again, it really depends on who is going to benefit from this. If only one entity is going to benefit from this or be harmed by this, then there's no choice but to disqualify yourself. If it's 3 or more, then you can disclose that interest and proceed to consider it. Here's a slide that deals with disclosure and disqualification arising from representation. And this deals primarily with architects and attorneys, members of professional services firms, and whether or not their partners can represent people that come before the board. Disclosure and disqualification is required if you personally have provided services to an applicant that's come before the board. Disclosure is required if a member of your firm is coming before the board. So in other words, it's conceivable that a board member can still consider an application that comes before the board if a legal partner or if another member of the firm is doing the personal representation of the applicant. And then employees may represent themselves or a member of their immediate family in a transaction if they receive no compensation for the representation. So if any county staff members were the applicants, they can represent themselves. If you're concerned that a conflict might exist, the thing to do would be to contact the Commonwealth's attorney, the locality's attorney, or the public body's attorney, Mr. Bowling. Provide the attorney with a full written disclosure of the facts. Follow the opinion of the attorney because penalties for knowing violation include criminal fines and penalties, forfeiture of office, and the other penalties shown there. So if you get an opinion of the Commonwealth's attorney and rely on the Commonwealth's attorney opinion, that's been held to be a safe harbor from these penalties. So that concludes what I had to say on those 2 subjects. John, you had a question?
I'd like to go back. This is, again, I want to sort of ask the question in the reverse.
Okay.
I understand the conflict of interest provisions are basically requirements to not participate in something where you have a defined conflict. But just speaking of this, like in a personal way that I think is also a general thing. I live on a private road. I've lived here for 30 years. I have very close personal relations with many of my neighbors. We're a tight-knit group, and I can picture land use situations coming up amongst my neighbors. I personally would be, in layman's terms, extremely conflicted to get involved in a question with my neighbors like that. I value my relations with my neighbors more than this body, I would have to say, wanting to be responsible in both ways. And I just wonder about almost like how you or like other members of the board would take my decision to withdraw from hearing a case that was that close to me personally, although, in spite of the fact that I had no financial interest in it whatsoever.
That's a very good question. And again, my response would be that under the Conflicts of Interest Act, unless there was a financial interest, that wouldn't come as a conflict under the Conflicts Act. Now, having that, I can understand what you're saying, that there's might be the appearance of impropriety, that you yourself might actually feel swayed regardless of whether or not there was a financial interest. And in that case, I mean, you have the ability to disqualify yourself or to disclose your interest and to proceed. Neither of those would be required by the Conflict of Interest Act. But if it's a situation where you feel that you would not be able to judge the application fairly, then the safest course is simply to disqualify yourself and state the basis for your disqualification and put that on the record.
Okay, I would say, I mean, I'm not thinking about anything in particular, and I don't want to, dodge my responsibilities in this position, but I can imagine situations where I would feel conflicted to the point where I just wouldn't do it.
And that's certainly your prerogative. The one thing I would say is there is such a thing as disqualifying yourself too much, in the sense of when you disqualify yourself, then your representation on the board is the board is at that point not dealing with the full spectrum of participants. The board loses something when a member disqualifies him or herself. And if there's a conflict under the Conflicts Act, that's a good thing. But if people are too sensitive about disqualifying themselves, then the remaining members of the board don't have the benefit of their input. So that would be my one caution of not to disqualify oneself over every minor potential conflict. But I see that Francis has a comment.
Just as a question,
I understand that point.
as far as with John, how does that reflect to forming a quorum when there is need? Is the person being there a quorum, or if they disqualify themselves, is there no longer a quorum for that item?
Yeah, and as we discussed earlier, the body can't lose a quorum based on conflicts. So for example, if the meeting starts out with 3 members, and then at some point one of them is conflicted out and there's only 2 members left, then the body doesn't lose its quorum on account of a conflict. So, Mr. Rob, you had a
Yeah, Mr. Chairman. Is there a legal way to secure the opinions of other members of the board related to whether or not they feel that you have a conflict? It basically to determine, to get an approval whether or not you should withdraw.
Mr. Rob, if I could caution you, I mean, I'm certainly happy for other board members to respond to that, but it's really not the opinions of the other members of the board that matters. I mean, their opinions might be helpful, but ultimately it would be an opinion of the Commonwealth's attorney or the public body's attorney that would be more meaningful in terms of advising on whether or not there was a conflict. I would sure hate for members to agree, oh yeah, that doesn't seem like a conflict, when in fact the law indicates that it is. I think that to the extent that there's a concern about there being a conflict, that opinion from the Commonwealth's attorney provides a better defense than the opinions of other board members.
Mr. Chairman, having been here around this barnyard enough, I've now realized that perhaps there were several times that I did not need to withdraw because I felt there was a conflict of interest. Since we have our own counsel, I'd just like to have the understanding amongst my fellow members, board members, that we channel through Jim our concerns if that happens, and then make sure that John is aware and not go into a meeting. I have to tell you, there were several moments in some meetings, and I'm talking about a long time ago, where a member comes in and all of a sudden decides in the middle of the meeting that he has a conflict. And I one particular one was a very serious one, and that board member is no longer with us. But let's be adults here, and if we sense it, let's talk to Jim individually, and then make sure our chair knows what's going on before a meeting takes place.
And I have to tell all the board members, if I have any doubts at all about what you're asking, whether or not it's a conflict, I tell you to refer it to the Commonwealth's attorney, and I play an active role in setting up that communication so that it make it as easy as possible to you. And I've done that on not many occasions, but more than a handful of occasions, because you don't want to get in a situation and giving you advice when your say-so is not the important say-so that you need. And under the conflicts of interest statute, as Andy keeps telling you, it's the Commonwealth's attorney that really weighs in on interpreting this act. But don't at the same time, if what you say to me is clearly doesn't rise to a legal conflict, I'm going to tell you that. And if I have any doubts, then I'll talk to Andy and others about it. And I'll also say that if you feel that you have the appearance of a conflict, although it doesn't prevent you from acting on a particular matter, then you certainly can respect your ethical wishes and declare that you do have a conflict because it creates an appearance.
And I think Mr. Reinhardt raises a very good point that to the extent that you have any concerns, the best time to raise them is in advance of the meeting, because A, that gives the Commonwealth's attorney or the BZA's attorney more of a chance to weigh all the facts, to collect all the facts that are relevant to the determination, and to prepare all the forms that are needed for the record, because it's when you disclose a potential conflict or disqualify yourself, there actually is paperwork that needs to be filed with the secretary of the BZA. So if at all possible, if you foresee anything coming, please alert Jim to that in advance of the meeting.
I've also noticed sometimes in past meetings where I've seen the conflict issue arise in describing your conflict, it creates a strange influence on the rest of the meeting. You know, knowing that someone is a very good friend of someone else's, but doesn't want to vote. Suddenly you're just, you're thinking about personal relations and not the points of the case in front of you. And to keep all that, to keep that out of the meeting is a good thing.
I've just had the experience twice. Once when I was on the planning commission and there was something going on next door, and I talked to the county attorney asking whether or not I should be involved in the conversation. And he told me that this was going to be something that would affect the whole community, and my input was valuable because I was a neighbor. So I was able to stay on and make a decision. I was on the Architectural Review Board, and I did have to send a note to Denise Lunsford, and she didn't agree with me. She thought I was in conflict. So I had to leave that meeting. But I mean, it's not, I guess what I'm saying, it's not a big deal. You just make sure that you think about it prior to the meeting and get some sort of advice prior to the meeting, instead of expecting the attorneys to figure it out off the cuff. So that's all my advice. Sometimes you win, sometimes you lose.
Andy, let's say that it's determined that there is a conflict. Should I assume that Bart needs to let the appellant or in the other side know that there's one member that is going to withdraw from a determination?
I don't know that that's a requirement in advance of the meeting. I think that before the matter comes up, that's the point at which the disclosure or the disqualifications into the record.
But not literally before the meeting itself.
It's not a requirement.
Okay.
And if a member is disqualified, there's really not a remedy for the applicant. If a member is absent for other reasons, that may sometimes enter into the equation of whether an applicant wants to request a deferral. But if a member is disqualified, a deferral isn't really going to fix that. I've come to the end of the slideshow, and I went ahead and took down the slide just so that we could have better eye contact here. But the last slide just points you all in the direction online. The Land Use Law Handbook, the materials that you have today are derived from the Land Use Law Handbook, which Greg Campton put together, and which is really an excellent resource. And the good news is that it can be found very easily online at albemarle.org/land-use-law. So that's albemarle.org/land-use-law. The entire Land Use Law Handbook is online. We've given you in the materials excerpts from 11 chapters of it, but I believe it's over 30 chapters at this point. And as I've said, whenever I give this at statewide trainings, people say, oh yes, we look at the Albemarle Land Use Law Handbook, because I think it really is a helpful resource. So I would, it contains everything you wanted to know, but didn't know who to ask about land use law in Virginia. So I'd encourage you all to take a look at that.
I'd like to just wave the flag on that. We take, for those of us who are here in Albemarle, we take it for granted and assume every county's got their land use law handbook, of course. Actually, the work that first Greg did, and I'm sure, Andy, you've contributed to that, and others in the county attorney's office have contributed to that. That is the gold standard. As far as I understand it, that is a gold standard in the state. It's referred to and just held in just high regard and respect. And it's just a great thing. I appreciate it. We all do. It's a big deal.
I do too, and I deserve extremely little credit for it, because Greg continues to be the one that not only has compiled it, but keeps it updated. So
I understand.
So I can toot Greg's horn. But yeah, I agree. I think it's a very good resource.
Yep.
So I'm happy to address any other questions that might have come up, either from our discussion today or from what we discussed at the last meeting. But that concludes what I had planned to say.
Okay. Well, we're all here this is a good opportunity to just, I would say, take some time. We could broaden this discussion. We are in a meeting where we don't have a case in front of us. So this is a chance to discuss things that of a legal matter or just procedural matter or whatever that might be on people's minds. Does anybody, any discussion points like to have here? And I'm glad I see Francis is here. Francis, don't leave. Marcia?
I am still pondering over the case with Yancey. And the reason I'm pondering is because of the fact that there was a remedy for Yancey, special exception. I do realize they had so many pieces of equipment, operations that were not in compliance. I get that, but they were searching. Well, they were involved in the process for 2 years to get before the Board of Supervisors to receive or not receive a special exception for everything they were not in compliance with. And yet they get a letter from zoning that says, you're not in compliance here. And I'm thinking, what's the point? They know they're not in compliance. They are trying to remedy the situation. They're going through this process. So all of a sudden we are told that there are 2 pieces of equipment that are not in compliance. And we're saying, yeah, we see this plat, they're not in compliance. So what is the point of taking this applicant while the applicant is going through this process and telling them they're not in compliance and they have to stop because they're not in compliance? I mean, I have had a real trouble trying to figure that one out as to why put the applicant through that process and procedure when they were, as their attorney said at least 7 times, diligently pursuing this special exception.
I hesitate to get into the specifics of specific cases. Sometimes it can be that an applicant that problems with a particular property are called to an owner's attention. The owner begins an application, but then doesn't diligently pursue it. And that's the point at which the zoning administrator might need to make a more formal determination and put them on notice of a violation. So again, I don't want to speak to specifics of specific applications, but if an owner is files an application and then sits on it without taking further action, that's the point at which a further enforcement action by the zoning administrator is entirely appropriate.
But I guess the thing that was kind of interesting to me is that they were violating so many different, I don't know how many there were, 30? I don't know how many pieces of equipment were too close to the property line. And yet there were only 2 that were cited. So within the letter that was appealed to the board. So I just thought, why are we doing this? Because we met several times and didn't do anything except defer it until it went through the board. So it just seemed as if, why are we doing this? Why are we spending so much time on this when they are going through the process? And which also comes to mind is what's happening with applicants themselves. If I'm coming in and I can get a special exception from the Board of Supervisors, or I could get a variance, what's going on with zoning? What are you telling people? And how do we not have this conflict continue?
I think you're perceptive in that a lot of what was being discussed here was more a matter of timing than anything else. And what complicated the timing was the fact that we had the outbreak of COVID right at the point at which a particular application was going to go to the Board of Supervisors. And then there was a question of, since this matter was pending before the BZA, what formal steps did the BZA have to take to defer it as the applicant was requesting? So I share your frustration at the amount of time and the length of the meetings that the BZA had to consider this. I think that a lot of that wouldn't have happened if not for COVID. If all the meetings had occurred in person and on schedule, it would have followed a timeline that probably would have worked to everyone's preference.
I get the COVID thing, but I don't get that letter. I still do not understand why the letter was sent telling the applicant that you're not in compliance when the applicant obviously knew they were not in compliance because they were pursuing the special exception.
Well, again, I don't want to get into the specifics of specific appeals, but suffice it to say that oftentimes a zoning administrator has to remind applicants of their non-compliance if an application is sitting dormant.
Okay.
So yeah, based on I'm kind of following Andy's lead, and so when we have folks that we've been speaking with who misunderstand or pull the trigger a little quickly on things that they're doing, and because like all those special exceptions, say that Yancey got, or any other applicant, they're supposed to get those prior to the beginning of the use. And so we'd have to go back through a specific file or a specific case to see kind of where those things start. But generally what happens is there's timetables involved in enforcement. And if you meet them, we move on to the next milestone. If you don't meet them, then we figure out how to get through to the applicant that you need to meet your deadlines. And so depending on who's telling the story, there's a different version of what is diligent and what isn't diligent based on what we have going on. So, I don't know. I don't want to kind of call out any of our applicants or any of the folks that we're working with, but sometimes there is a disagreement on what diligent is and what should be submitted and when it should be submitted. So in order to keep the process moving, because the ultimate goal is compliance, and then a letter of violation is just a tool to get compliance, meaning that tool either results in the right things being submitted, so there's an approval and you operate in accordance with the ordinance and the laws, or it's a tool so the applicant understands that they don't want to comply, they're going to have to stop doing what they're doing, which in itself is compliance.
Okay, so when I submit an application, is there a time frame that application has to be heard, completed, and approved or not approved? Or can that go on for the rest of my days?
So there is a timetable that the county is supposed to act on an application. I don't want to mix things up, because if you're
Right.
an applicant who is
Right.
proposing a use
Right,
and you submit your application, I want to make sure we key in on the right word, proposing a use. That means the use is not taking place. So therefore, until you get approval, you're not supposed to be doing that use. That's a different thing than if you're operating something without the right approvals, meaning in violation of the ordinance, and we have to have a compliance program. So a compliance program has steps that says, okay, step one is to do X. It may be to submit something, but it may also be to stop the use, because we cannot give permission to continue officially. So those are some of the things we have to look at on a case by case basis. If you're doing what you're supposed to do, there is a timetable to get your application processed so you can begin your use as quick as possible. If you're already violating the ordinance, that's a different thing.
okay, I think I'm getting what you're saying now. So if you're in violation, you should stop.
Yeah.
Okay,
Okay, thanks for that.
thank
I
you.
want to, going to take a chance here. I want to round back on a question that I've had for a while, and I'm not quite, I want to talk about the relationship between special exceptions and variances one more time. And I'm glad to hear this in front of Francis and Bart, in addition to the members of the board, because I think it plays on both sides, both before an application, what applicants are told before an application is made, and also how the BZA will handle these things afterwards. And the nub of the question for me, and just sort of my point of confusion, I would start with the provision in the part of the zoning ordinance that deals with criteria required to be met for a variance. There's about 6 of them there, and the last one is you cannot. My reading of the ordinance says that you cannot grant a variance if a special exception is available. And in other parts of the ordinance, there are places where special exceptions are made available, mainly in section 4, setbacks in just about every zoning district, I think, except rural areas and village residential, which means that in a, like the Yancey thing, so just taking the Yancey thing, for example, there was a special exception available for all those setbacks in that industrial district that was available, and that we would not have been, my reading is that staff would have to recommend denial of the variance because it's just pure and simple, not available. And the BZA should not grant the variance unless they want to wind up in court again, and probably lose on that point because of that statement. That's sort of how it looks to me. But I know that I think, Andy, you have said that I think I understood you to say at some point along the line, and it's not clear to me yet, that an applicant would have the choice about what avenue they wanted to pursue, whether they wanted to go for a special exception with the Board of Supervisors or variance with the Board of Zoning Appeals. And it could be a choice. And I would like to clarify that point. I think it's important that the staff as consistently gives the same advice to an applicant or just, a citizen in that situation where they're either, where they're like wanting to do something outside a setback or have been caught outside of a setback, whether it's either a violation or, applying for a variance or a setback change. What the, clear direction to the staff on that. And I'd like to hear an opinion on how the board should approach that. Sorry to be whamming away at the same horse, but I'm asking the question.
So I'm happy to take the first crack at that. As we've discussed, special exceptions for setbacks on the one hand and variances on the other hand are not mutually exclusive. So in other words, an applicant can choose to apply for a special exception for a setback and or a variance. It's not as though it's not an either or choice. Most folks typically think along the lines of a variance, and therefore that's what they apply for. Now, I can't speak for Mr. Svoboda, and I don't know exactly how applicants are advised when they come in. If they come in and they say, I want to apply for a variance, we will provide them, I imagine we will provide them with the paperwork to fill out an application for a variance. But I'll defer to Bart as to how exactly applicants are advised when they come in that situation.
Yeah, so we would look at what they're asking for. So if they were asking for a variance for setback, we would look and see where, we would analyze the situation, and if it's a setback that can be reduced by special exception, then we would direct them we would put them in that direction as opposed to a variance. One of the reasons for that is the variance criteria is very strict. The special exception criteria is not. So if we take and I'll make up an example. If I have somebody who adds an addition and violates the setback, a strict interpretation, and we can argue about how strict, but a strict interpretation of the variance criteria means basically that's self-inflicted. You didn't follow the ordinance, you can't have it. The special exception is different than that. It doesn't have that strict criteria. So there's a different analysis that the Board of Supervisors can do that talks more about character of the area, consistent with development of the area, things like that. And I'm kind of cherry picking the easier ones, but their criteria is a little less. It's more about, for those of you that are familiar with kind of rezonings, it's more about trying to decide if the setback is appropriate for the district or the area that it's in versus strict adherence to the law. So on the BZA side, we're talking about the speed limit is 55. If you're going 56, you violated the speed limit. On the special exception side, it's, well, the speed limit says 55, but is 56 really say it's a kind of more objective, safe analysis, if that makes sense. If I try and put it kind of into layman's terms.
Well, to make for an example, the Yancey case is over and done, but it provides a good example. So it could have been just launch ahead and then I'll back up. Okay. Let's suppose the Board of Supervisors said that thing that was close to 250 was too close, and they granted 26, but not 27 special exceptions. That remained a violation. So it seemed, had that happened, Yancey could have come to us and said, we want a variance for that. How would a lot of the criteria for variances are subjective? It's the matter of defining the word reasonable. For example, it's like the biggest criteria, a very important criteria is the reasonableness thing, and that's not black and white. But if my reading of that would have been that the staff would have to be very definitive about us denying that variance, because you can't grant a variance when a special exception is available. I mean, I just don't see, I think to me that I just see that distinction there, and I just see that heading us in that these things are divided up, either heading to the Board of Supervisors or to the BZA. And I don't think the ordinance contemplates the BZA and the Board of Supervisors getting into a conflict over something like that. I think it's very probable. I think is very problematic, and I want to hammer it until.
Yeah, let me touch on process for one quick second. So what we can't do if an applicant comes in is tell them you can't apply for the variance, okay?
I
Even though they
understand.
can't get it,
Really
right?
not-
So, right.
That's not the point I'm working. I know you can ask for anything, but I'm taking it a step further about how the staff is going to approach that, and how we would, how that item would follow itself all the way up through our process and up through to the courts.
Right. So for me, it's similar to this. I own a commercial piece of property that has commercial uses permitted by right. I come in for a building permit for a single family house, right? It's denied because I can't have a single family house in a residential district. That's just how it works. The use is not permitted. Okay. They're going to appeal that decision to the BZA because they think they should have a house, or I think I should be able to have a house in a residential district. Our of course staff would say, no, you can't. It's cut and dry. The use is not permitted. It's similar to that, meaning that that special exception for that particular thing is permitted, period. It's not under the BZA's purview. So with the house example, the BZA doesn't have the ability to grant a variance for me to get a house because that's just not in the purview of the BZA. It might seem reasonable because all the other properties all around it are surrounded by houses, but this one isn't, but you still can't do it. It's in staff's opinion, right? It falls into that same bucket of things of not being able to go there. I don't know if that helps or makes it worse. Andy, you add in anything?
Well, I would like to go back to a question that Mr. Shepherd has raised as well, and that is which takes precedence, the county ordinance or the state statute? And as I pointed out, there's actually a slight discrepancy between what the ordinance provides and what the state statute provides. And when that happens, the controlling authority is the state statute because a county cannot exceed its enabling authority. So I would encourage the board, to the extent that there are differences between the ordinance and the state statute, to look at the state statute. And in the case of the state statute, again, the application for a special exception and the application for a variance are not mutually exclusive because, again, the state law does not preclude an applicant from seeking both simultaneously.
Well, I don't have a follow-up question to that, except that maybe the next time we'll really drill into this is the next time it comes up.
Meeting's been very helpful. Thank you all for your preparation and your answers that got me to where I needed to be. Thank you.
Thank you all. Thank you for the invitation.
Yeah, I think, I think this is really, I've wanted to do this for a long time. I just really appreciate, the training and just, and this last discussion, we usually just can't get into the weeds like this, but it's good to get into, I think it's good for us to get into the weeds every now and then. And I think you all, staff have, I think this would help staff see it from a board standpoint and the board see it from a staff standpoint. And that sort of back and forth, I think, is a valuable thing. It's just, it's just strengthening our whole, just the capacity on both sides. So I appreciate it. I hope we can continue to do, brush up on this every year or so. Don't have to wait for a problem, but just make this something that we do, just as part of the annual experience. Hope that could be the case. Any other new business?
We do have 2 applications coming in December. One is a variance in the rural areas. The other is an appeal. So those 2 will be on the December meeting.
Right. We're ready. So I think we've seen the, just have a hint of what they're both about from the preliminary, the preliminary stuff, the packet that has been sent out. Look forward to the rest of that. Sure enough. Okay. I think I've hit the point in the meeting where I've asked for a motion to adjourn. If there's not anything else on anyone's mind.
So move.
And is there a second?
Absolutely. Oh, excuse me. I've just made the motion.
I second it.
Why don't everyone signify agreement by raising their hand? I believe that's a unanimous vote to adjourn. So
Thank
with
you all
that,
very much.
thanks, everybody. See you all in December. Have a
Happy
good
Thanksgiving.
however you figure out how to do that. It's one thing to have a meeting by Zoom, and having a family Thanksgiving dinner by Zoom is a whole nother challenge. Good luck with that. It's a wonderful holiday. I hope you find a way to make the best of it.
Y'all take care.
Thank
Okay.
you, guys.
Thank you all.
You and bye.